So today's topic of what I'm going to be talking about is going to be on Masonic jurisprudence, aka Masonic law. Um, so this is what I'm going to be talking about. Um, so for the disclaimer, the views and opinions expressed by myself does not represent the views or opinions of the lodge or Grand Lodge in which I hold membership. So the topics that I will be covering, and pretty much because Masonic jurisprudence is such a very, very big topic, covers a lot of things. I will be doing this in part. So this is part one, and then later on we will hit up part two on Masonic jurisprudence. Um, so the topics I'm going to cover is the three categories of Masonic law. I'm going to cover Masonic trials, and then when we go into part two, I will finish up on Masonic trial and go into Masonic punishment. So, continuing on, what is Masonic jurisprudence? The dictionary tells us that jurisprudence is the science or philosophy of law. When it comes to Masonic jurisprudence, Joshua Drummond, a American Masonic jurist, defines Masonic jurisprudence as the knowledge of ancient uses of the craft and of the landmarks and of the laws of our institution. So I pretty much narrowed this down during my research and talking with a lot of older brothers. I've categorized Masonic law into three categories. So the first one is your historic / landmark laws. Your historic / landmark laws cover the 25 ancient landmarks, our obligations, the ancient charges, and customs and traditions that we have in Masonry. The second would be constitutional law. That covers the Book of Constitution, lodge bylaws, as well as edicts. And the third constitutes moral law, which is personal standards. So I'm going to pretty much start with historic landmarks. So under historic landmarks, like I said, we have the 25 ancient landmarks. The 25 ancient landmarks, in 1858, Albert Mackey defined the landmark into 25 different parts. For brothers out there, if you are not familiar with 25 landmarks, I suggest that you go under the Google Classroom. Our secretary, Brother Josh, has done extensive work with the Google Classroom. And in the Google Classroom, there is a link that has the ancient 25 landmarks. It has it listed out of what they are, and it explains further of what those 25 landmarks are. So that's pretty much the first type of laws that govern Masonry. And pretty much any regular jurisdiction will follow the ancient landmarks. If y'all remember about Josh's presentation at our last conference, he went into the difference between clandestine and irregular. So, going with the landmarks, this helps define regularity. One of the 25 landmarks is that you shall not initiate, pass, or raise anybody who is atheist. So if there's a jurisdiction that's doing that, that would constitute them as irregular, i.e. meaning they're not following the ancient landmark. Per our Constitution that is given to us by the Grand Lodge, the Constitution states in Article 11, Section 2, ancient landmarks are those principles of Masonic government and policy which are the only part of Masonic law or rule of government that may never be altered nor disturbed, and such of them as are lawful to be written are usually, but not wholly, engrafted in written constitution and general or special legislation. All right. So another thing is with the ancient 25 landmarks, they cannot be changed. They cannot be altered. There's no amendment that can be done, nothing. The 25 landmarks are what they are. And like I said, I'm not going to go into all the landmarks due to our time. So the next is obligation law. These are obligations that we take in Bluecraft Masonry. All right. So when we take an obligation, when we are obligated, that obligation is a set of rules that as Masons we are governed by. Now, with the obligation, there are 4 obligations in Bluecraft Masonry. 3 are general obligation, and 1 is what I consider a position obligation, because you are given that obligation depending upon the position that you hold in the lodge. So the 3 general obligations are: you are obligated in the entered apprentice degree, obligated in the fellowcraft degree, and you are obligated as a master mason. That last obligation that I said was a position obligation. That is an obligation that is given to a brother who has been elected as master of the lodge. So if y'all remember, for those who've had the privilege of watching, the election and installation ceremony, during the installation ceremony, whether the brother is newly elected or re-elected, that brother takes an obligation pertaining to the master's chair of being master of the lodge. And next, which this surprised me upon doing my research, was the charges. And this has given me a newfound respect for the charges, because in doing degree work, sometimes I found myself being tasked out to give the charge, whether it's in the first degree or second degree. And so now it gives me a newfound respect for the charges, because when I'm giving those charges, or any brother who's giving those charges, you are giving a set of rules that we are governed by. So when it comes to the charges, there are 5 charges in the blue house. 3 charges are the general charges. 1 charge is a lodge charge, and then you have 3 position charges. So continuing on with the general charges, of course, it's the same. You have a charge in the entered apprentice degree, a charge in the fellowcraft degree, and you have a charge as a master mason. The lodge charge is given during the installation ceremony. So once again, if you've seen the installation ceremony, towards the end of the installation ceremony, right before the proclamation is given, there is a charge that the installing master gives until the entire lodge, that as a lodge, those are the rules that we must follow as a lodge. And then the position charges, there's a charge that's given to the junior and senior warden, and a charge that is given to the worshipful master. Continuing on, is the constitutional law. So the Constitution is given to us by the Most Worshipful Prince Hall Grand Lodge of the state of New York. That is the Constitution that we must follow under this jurisdiction. As a rule of thumb, you can find the Constitution, and once again in the Google Classroom, but I implore that all brothers should have their own version of the Constitution, and you should be bringing it with you to every meeting. So when we are able to meet again, you should have the Constitution, the book of Constitution with you handy, because you never know when something might come into question. And it's good reading. Not only should we be reading our ritual, but we should be reading the Constitution, because these are rules that we are governed by. Now, the Constitution that is given to us by the Grand Lodge states in Article 11, Section 3, a constitution is a written contract or law adopted by Freemasons for the government of a Grand Lodge and its subordinate lodges and their members, including fundamental provisions constitutionally adopted, which is to be permanent in its character. All right. The bylaws, which is another tool that as Masons we should have in our arsenal, is given to us by the lodge where we hold membership. So all brothers are members of St. James. You should have in your possession the St. James bylaws. And then we have lastly the edicts, which edicts are given to us by the Grand Master. The fun thing about edicts is the edict is issued, when the edict is issued, it only lasts while the Grand Master is in office or the edict is repealed, whichever comes first. All right, that's what comes from edict. Now, a good question is what gives or who gives the Grand Master his prerogative? As we know, the edict comes from the Grand Master, but who or what gives the Grand Master the authority to come up with those edicts? Well, that would be your ancient 25 landmarks. The Grand Lodge does not give the Grand Master his prerogatives, nor do any lodge or brother. Prerogatives come from the ancient landmarks. So once again, read the ancient landmarks and you'll understand that the Grand Master's prerogatives, the Grand Master's powers comes from the ancient landmarks. Continuing on, customs and tradition. So the difference between a custom and a tradition is a custom is something that is done, that is passed down individually or, locally. It's something that is not done wholeheartedly across the board, but it's something small. To give you an example of a custom is during our club meetings, the worship master is the last to speak, and no one is permitted to speak after the worship master. That is a custom because that's something that is not done across the board. If you were to go to other jurisdictions, you might not see other lodges adhering to that custom. But that is a custom that we have within our lodge, within our club meeting. Traditions, on the other hand, is something that you would see that's done across the board. It's something that is also passed down from generation to generation, but it's something that, once again, is done no matter where you're at. So a prime example of a tradition would be when we are preparing the candidate for the first degree, we prepare a candidate by being divested of all metallic substance, neither naked nor clothed, barefooted nor shod, left knee and breast bare, hood, wing, and cable toe around his neck. That is a tradition that we do when preparing the candidate for the first degree. That's something that you will see no matter in what jurisdiction you are in, you will see a candidate prepared like that, if it's a regular jurisdiction. So now traditions can be customs, but customs cannot be traditions. So I should give you a little, tidbit on the difference between customs and traditions. But nevertheless, customs and traditions are laws that we, as Masons, we must follow. Customs and traditions oftentimes may be written or unwritten. So, whereas the 25 landmarks, you can go find that in a book. The Constitution, you can go find that in the book. Obligation charges, you can find that. Sometimes customs and traditions you will not find in a book. That's when our good past masters come into play of making sure that those customs and traditions are passed on. Now going into moral laws, which is the third category of Masonic law. The dictionary states morals as a person's standards of behavior or belief of concerning what is and what is not acceptable to do. So it would only be fitting that we as Masons, we should have high morals about ourselves. What is our model? We take good men and we make them better. We don't take bad men and make them better, or we don't take bad men and make them good. We take good men. So right off the jump, we are looking for candidates who have high morals about themselves. And then we just fine tune those morals. All right. Now, here's a question. that this is a question I had when doing my research, is since morals are personal, all right, meaning that what I find to be moral, you may find to be unmoral. How can a Mason be charged for breaking a moral law that is personal? Well, to answer that question, a brother files those charges, but in the end, the lodge will decide what is moral and what is not. And because the lodge decides what is moral and what is not, that means that those cases are handled on a case-by-case basis. Because an action may be moral in one sense, but in another sense, may be unmoral. So when it comes to a Masonic trial, that is something that the lodge will look at, is they will look at the context of the action that was done and decipher whether it was moral or unmoral. So that is on moral law. Now, I've covered where we get our Masonic laws from, where we derive our Masonic laws, where you can do further research upon yourself and dig deep more into Masonic law. Now I'm going to enter into Masonic trial, or Masonic trials, and how Masonic trials are handled Masonically and in this jurisdiction. I got my timer on, so I'm doing a little bit good on time. The only object of a Masonic trial is, number one, to seek the truth. So that is the main objective of Masonic trial. So, the beginning, the preliminary step in every trial is the accusation. In the Masonic language, we call the accusation the charge. So, when somebody refers to a Masonic charge, they are referring to an accusation of a Masonic offense that has been broken. Now, there are two types of ways charges are filed. First way is called informal charges, and the second is called formal charges. Now, the way charges are filed, we determine how the charges are handled. So, if you file informal charges will be handled differently than formal charges, because informally, the charges are handled pretty much in-house. Formal charges means that there is a written record and that those charges have the potential of being handled out of house, i.e. meaning the Grand Lodge or the Grand Master, so forth and so on. The Constitution, and once again, you'll hear me refer to the Constitution a lot when it comes to Masonic trial. The Constitution states in Article 27, Section 1, prosecution for a Masonic offense must be commenced within 3 years after the commission thereof. So that pretty much means that there is a statute of limitation on Masonic offense. That means you have 3 years to file Masonic charges, whether it be informally or formally. You have 3 years to file Masonic charges from when the charge event actually happened. So now I'm going to talk about informal charges and the steps that are taken for the informal charges. So the first step in a formal charge is to inform the junior warden that you would like to file informal charges. In this jurisdiction, the junior warden serves as a mediator for the lodge. So the first step is to contact the junior warden and pretty much advise the junior warden that you want to file informal Masonic charges, and let the junior warden know what the situation is, what the problem is, so that it can be mediated. The second step is to work with the junior warden and any other brothers who may be called upon to help mediate the charges, all right? So when it comes to informal charges are pretty much a way of mediation. To give you a broad example, let's say you have brother A who is mad at brother B because brother A had loaned brother B a lawnmower, and brother B has failed to return said lawnmower. All right. Well, in that situation, you might want to go the informal charges route, and the junior warden, you inform the junior warden, and then the junior warden will act as a mediator between brother A and brother B to make sure that both parties leave away happy. Now, some of the things to take away from informal charges is that there is no written charges, meaning you do not write this down. It's pretty much, when you're doing informal charges, it's pretty much verbally. So you would inform the junior warden, and this is pretty much done informally. All right. Second is like I said before, informal charges is used as a tool to help mediate problems. Number three, the lodge does not have to be informed of informal charges. So the only people that have to be informed of the informal charges is both parties, the junior warden, and whoever the junior warden designates for assistance. The junior warden may reach out to the worshipful master for assistance. Junior warden may reach out to past masters for assistance and help with mitigating the informal charges. Number four, because there is no, because it is informal, informal charges does not lead to a Masonic trial. And because there's no Masonic trial, the meeting can happen at anywhere, at any time both parties agree. So it does not have to be during the communication or after communication. It can be at a club meeting. It can be, parties going to a restaurant, sitting down and eating. It can, once again, it can be anywhere at any time. And because there's no Masonic trial, the result will not end with a guilty or non-guilty verdict. And because since there is no guilty or non-guilty verdict, there will be no Masonic punishment. Masonic punishment cannot be rendered. So like I said, informal charges are more of a way for mediation. All right. Going now into formal charges. All right. So the first step in formal charges is the accuser must have the charges written. All right. So the accuser must write a letter stating that he is filing formal Masonic charges. The accuser must sign it and place the letter into the hands of the lodge secretary. Now, one of the things that if you are writing a letter of filing formal charges, one of the things you want to remember is you must state the 4 W's. So number one, you must state who's writing the charges. You have to state that you're writing those charges. You literally have to put your name in the letter that you're writing those charges, and you must state who the charges are against. All right, so you have to put the brother's name of who you are filing the charges against. Second, you must state what the Masonic offense is. Now, there is a Masonic offense that is widely used in the Masonic realm, and that is the offense of unmasonic conduct. But per this jurisdiction, because the title of unmasonic conduct is so basic that you must specify the particular nature of the conduct which is to be unmasonic. So if you are using the charge of unmasonic conduct as filing formal charges, you must state what the conduct is. All right. Number three, you have to state where did the Masonic offense occur. Number four, you have to state when the Masonic offense occurred. And lastly, the letter should also state a brief description of the event causing the Masonic charges. Doesn't mean that it has to be lengthy. You just need to give a brief overview of the event, of what happened, of causing you to file those Masonic charges. Now, one of the things that it doesn't say, but one of the things that I would personally add is when also forming this letter, it wouldn't hurt to also list any witnesses that may be around. It wouldn't hurt to list that when you're filing your formal charges. So example is let's say brother A overheard brother B talk to brother C, which brother C is a fellow craft. Brother B revealed the secrets of the Master Mason to brother C. Brother A overheard this, let's say in the preparation room, also around were 3 other brothers. Brother A is following the charges. Brother A should also list the 3 other brothers who were present as witnesses. So continuing on. All right, so after you have written the letter and you have signed it and you have turned it over to the lodge secretary, this letter is now the property of the lodge, which means that the letter of the formal charges cannot be altered or amended unless the lodge consent and the accused has been informed. So once you've done this letter and you've placed it into the hands of the lodge secretary, it is a lodge property. You cannot ask for the letter back. You can't change the letter. You can't do anything. It now has to take its usual course because it is the property of the lodge. Now, when the lodge secretary receives that, the lodge secretary must then read the written charges at the next stated communication so all members of the lodge are informed. So whereas informal charges, the lodge didn't have to be informed, only the parties involved in the junior warden and who else is assisting in that situation is informed. When it comes to formal charges, all brothers of the lodge has a right to be informed of the formal charges. All right, and that's why the secretary reads it at a communication. So all brothers are then notified that formal charges have been filed and that a Masonic trial will soon follow. Also, this also leaves a written record because it will be added into the minute book, and that letter will be put into the archives of the lodge. Hit my time. All right, I'm just about done. A copy of the letter must be given to the accused, and the accused must be informed of the date and time of the trial. So the lodge secretary must make sure that whoever the charges have been filed against, that person gets a copy of the letter, and that person is notified of when the trial will take place. The trial must commence at a regular stated communication, but may continue at a special communication. So what that pretty much means is when you're starting the Masonic trial must be at your regular stated communication. You cannot hold a special communication when starting a Masonic trial. The reason being is because all members of the lodge has a right to not only be informed, but also has a right to be present during the Masonic trial. So the way that the jurisdiction looks at it is as if you were to hold the Masonic trial at a special communication, it doesn't afford the opportunity for all members to be present. Whereas during a regular communication, all members would probably more likely be present at a regular communication. But so you start the trial in Masonic at a steady communication. But let's say time is getting away and the Masonic trial is dragging on, you can then recess the Masonic trial and then convene at another special communication. You do not have to wait to the next communication to continue the Masonic trial. You may even need to recess the Masonic trial because witnesses may need to be contacted and may need to be given their statement. So those may be some of the reasons why you might recess the Masonic trial, but you have to start it at a regular communication, and then you can finish it at a special communication. And lastly, no visitors are allowed in the lodge during the trial. So only the members of the lodge are allowed to be present during a Masonic trial. So if you have visitors, you may have the visitors in your meeting while you're opening up and going through lodge business. But once you get ready to start the Masonic trial, you must ask the visitors to retire because they cannot be present during during the trial. One of the things that it doesn't say, but this is one of the things that I've been personally told from a brother who's on the Works and committee is that even though it says no visitors are allowed, Grand Lodge officers, that excludes Grand Lodge officers if they are on official Grand Lodge business. So Grand Lodge officers are allowed. So they may not be a member of your lodge, but they are allowed to be present during the trial if and only if they are doing official Grand Lodge business. So I'm going to conclude part one. So when we do part two, I will be finishing up Masonic trial. I'll be going over the jurisdiction that lodges and Grand Lodges hold. I'll be going over the Masonic trial itself, how it's concluded, and I will be going over the jurisdiction, how the Masonic trial is concluded, and I will also be going over Masonic punishment if a brother is found guilty at the end result. For additional reading, for brothers who want to continue research, read the book of Constitution. You can read the trial handbook, which is also in our Google Classroom. You can read the book of Constitution, your ritual, and the bylaws. All those books are very important, as well as the Principle of Masonic Law by Albert Mackey. All those books are very important when it comes to Masonic jurisprudence and getting an understanding if you want to dig deeper into Masonic research and dig deeper into Masonic jurisprudence. So this concludes my presentation. If worse is okay, I'll open the floor up to any questions.
Yeah, thank you, brother Senior Warden. That was informative. Well done. I did mute everyone through this call just to avoid any background noise so we could share the information. And I will unmute everyone, but just as a note of reference, one of the books, because of my background, it's not shown. But anyway, one of the books is Mackey's Jurisprudence of Freemasonry. I do have that book, and I've gone through that book myself. If you're trying to figure out what the 25 landmarks is, it is identified right there in that book, as well as some of the documents that we have in our classroom as well. So I'm going to unmute for everyone for any questions for our Senior Warden. Really well done, Brother Senior Warden. Thank you for that. The two questions I have for you is, one, do we need to get, for a special communication, follow the same lines of the normal dispensation to get a communication for a Masonic trial, or is there another step? And then the second question I had for you is, at what point would a Masonic trial be moved out of the hands of the lodge and moved to the Grand Lodge? Or is there any situation that occurs?
Okay, so to answer your first question, ordinarily your Masonic trial, like I said, starts at your regular communication, so you do not need a dispensation for that. But like I said, in the event that you must recess the Masonic trial, whether it's to interview witnesses or because you're pressed for time and you want to continue later on and you need to hold a special communication, then yes, at that time you will request a special dispensation to do such. To answer your second question, there are two reasons why the Masonic trial may be taken out of the jurisdiction of the law. The first is if Masonic charges, if a brother wants to file Masonic charges against the worshipful master, if the brother is a sitting worshipful master. At that point in time, the lodge does not hold jurisdiction. At that point in time, the entities that will hold jurisdiction would be the Grand Lodge or the Grand Master. The second time that it would, second event that it would be taken out of the jurisdiction of the lodge is at the conclusion of the Masonic trial. The brother, if the brother is not happy with the verdict that has been rendered by the lodge, that brother has 60 days to appeal. That appeal would then go to the Grand Lodge or the Grand Master. And in the appeal process, more or less, they're going to act like the Supreme Court in a criminal case. All they're going to do is request all documents from the trial. They'll oversee, make sure that everything was done according to standards, policies, and procedures. And more or less, they will upheld the verdict that the lodge has rendered. But those are the two different ways that the jurisdiction forfeit. And when I go into part two, like I said, I'll go more into jurisdiction from the lodge. You'll be surprised to know that lodges do hold jurisdictions on affiliate and unaffiliate basis. So, you know, that jurisdiction does render with the lodge.
Thank you, Brother Senior Warden. That was very clear. I appreciate that. Brothers, any questions for our Brother Senior Warden on what he presented tonight?
Yeah, I have a couple questions. Just some procedural questions there. Number one, since visitors are not allowed to be in the communication when the charges are brought against the brother, if the witness is a member of another lodge, for example, would that visitor be allowed to attend for testimony, or would a statement be needed from that brother? That's the first question. Second question is, would the process be any different if the charges are against the junior warden or secretary? And the third question is, can the letter or charges be rescinded prior to trial since it's a property of the lodge?
All right, so to answer your three questions, so to answer your first question, what was the first question again? I got kids going on in the background.
Since visitors are not allowed in the communication for the charges, and if one of the witnesses were, say, a brother of another lodge, would a statement be needed from that brother, or are they allowed entry in order to testify to whatever they witnessed,
All right,
or may not have witnessed?
So to answer that question, and the visitors are not allowed during the Masonic trial, but the way that would be handled is the worshipful master would put together a committee, no less than 3, no more than 5, and that committee would be charged with gaining the interview from the witness, and also getting the interview of the witness. Accused must be present when the witnesses are interviewed. So let's say you're holding a Masonic trial, you could easily have the witness show up. You could, call when it's time to interview the witnesses, you can call the crowd from labor to refreshment. Your committee with the accused can then go out and interview the witnesses if the witnesses are present. And then the committee would come back, and then they would report to the lodge their findings of interviewing the witnesses. If it's not capable for the witnesses to be present while the Masonic trial is going on, then that's when you would recess the Masonic trial. Your committee would then get with the witnesses, schedule the time to conduct those interviews, as well as, like I said, get with the accused, because the accused must be present, conduct that, and then you would reconvene at a special communication or your next communication. You would convene, the committee would give its report on interviewing the witnesses, and then you could proceed with the Masonic trial.
Very well. So question 2, are the charges any different, is the process any different, rather, if the charges are against the junior warden or the secretary?
So for the junior warden, the process is different because, and when I go into part 2, I'll explain, each brother's role when it comes to Masonic trial. But to jump ahead, your junior warden serves as the prosecutor for the lodge. So if charges were filed against the junior warden, then the worshipful master would then put another brother in place as the prosecutor. The worship master could put, a past master to serve as the prosecutor for the junior warden. As far as the secretary, to my knowledge, no, there's no special course for a secretary. If a secretary was filed for charges, to my knowledge, in my research and in talking with a brother with the works committee, and then I was talking with another brother from the jurisprudence committee. No, there's no special course for secretary. But like I said, for junior warden, the junior warden would be recused, and the worshipful master would then choose a brother, i.e. a past master, to serve as the prosecutor for the lodge.
Great. And the last question was, can the letter or charges be rescinded by the accuser prior to the trial, since, as you said, it's property of the lodge?
No, the letter cannot be rescinded by the accuser. The only way that the letter could be rescinded is by the consent of the lodge, because it's the property of the lodge. So the lodge, the accuser would have to present why he wants to rescind the letter to the lodge, and the lodge would then have to take upon a vote whether to rescind the letter or have it take its usual course.
Very good. Thank you, sir.
But the accuser does not have the authority to do that. Only the lodge has the authority to do that.
James Usher. Brothers, there's a book of Masonic procedure trials that was issued back in, I don't remember what year it was issued, but 1993. It was issued in 1993. And if you go to Article 25 of your Constitution, not the statutes, the Constitution, it tells you the procedures for, part of the procedures for trials, charges, trials, and appeals. If and to assist the brother in answering that question concerning if the witness is a Master Mason, he will be called in to the trial to give what he says occurred. If he is a profane, which is not a member of the organization or an entered apprentice or a fellow craft, then we will have a committee that go and interview that brother, or that person, I should say. But if he's a Master Mason, he will be calling at the proper time to give to as the judge may so desire to hear his evidence.
So even as a witness, an entered apprentice or a fellow craft cannot enter the Masonic trial?
No, yeah, that's when you take the committee to get that information.
Oh,
it's on the third degree.
Thank you.
Right, because everything is on the third degree. Yeah. So if it's one of our fellow craft or entered apprentice, you will appoint a committee will be appointed, and that committee will go outside and interview that individual. It says the testimonies of profanes or of those who are of a lower degree than the accuser is to be taken by a committee and reported to the lodge, or if convenient by the whole lodge, when closed and sitting as a committee.
Mm-hmm.
All right. If you're a Master Mason, you will be calling at the proper time. Nice. At the proper time to tell the judge and the jury and the members what occurred.
Very good point. Thank you, Pastor Master Usher. Appreciate that.
So I have a question.
Sure, go ahead. So wait, just one quick question. Well, 1 second there, Josh. So we'll take a question from you. I know, Pastor Master Henderson, I think you had a point or a question that you wanted to add as well too. So We'll take yours right after Josh as well, okay?
All right, cool.
So can a person being accused of being charged have Masonic representation like a Masonic lawyer during the trial?
So, this is, I could not find any, anything on that. So I did have to ask, and the answer, the only thing I can tell you is the answer that I got was that the accused is allowed to have representation. That representation must be a third-degree Master Mason.
Correct.
Ordinarily, the accused, the representative, should come from the lodge. It can come from another lodge, but the rule of thumb is that lodges do not interfere with other lodge business. But that's the answer that was given to me is that the accused is allowed to have representation, and the representative must be a third-degree Master Mason.
Yeah.
In good standing.
We had we had a member of our lodge who actually was on trial, and he had someone represent him up in Syracuse. And the guy was supposed to be a lawyer, but he was in law school, but he wasn't technically a lawyer yet. So that's a whole nother story. But yeah, you have to be a third-degree Master Mason to actually get into a Masonic trial. The point I want to make was, you touched on something, Justin. First of all, excellent presentation, by the way. You touched on something, and what stuck out to me was ethics and morals. We have to understand that there's a difference between ethics and morals, because ethics would be something that the Grand Lodge would give us to do. Because think about it, when you go to a new job, they give you something and say, hey, here's the code of ethics that we have for this job. And when you say morals, that's what you think. That's what you as an individual think. That's why we say when we're making good men better, we look at that person like we make the judge, not the Grand Lodge, not anybody else. We make the judge. So we have to make sure that when we say moral law, that's our law. That's not anyone else's, that's just our law. That's all I had to say.
Thank you, Pastor. I appreciate that. And hey, Brother Senior Warden, really great work on your presentation today, man.